You're listening to a Kumaran podcast.
Hi, I'm Kumaran Thavarajah. I'm a partner in Kumaran's corporate M&A and finance team, and I'm an English lawyer.
And I'm Katherine Hensby, a director in Kumaran's banking and finance team.
And we're here today to talk to you about exclusion clauses. So, Katherine, tell us, exclusion clauses, where do these generally come up?
Well, they're relevant across a multitude of things, from commercial agreements, sale of goods, and M&A. If a service provider or a seller wants to be able to estimate total loss arising from a particular transaction or relationship, they would look to have an exclusion clause. The key question, I suppose, is how much is at stake? How much could I lose?
Yeah, I think that's a great way to think about them, right? So the starting point being, what type of exclusion clause do you want here? Do you want to exclude liability? Do you want to limit liability? And even, are there certain instances where you actually want to accept liability? And we'll come on to why that's important. And I think here, we'll kind of talk through this podcast. We'll talk through sort of 4 standard exclusion clauses we see quite often in commercial contracts, focusing on the English law perspective, right? So we'll look at the total exclusion. Simply do not want to be liable. Secondly, we'll look at exclusions based on the nature of the default. Then we'll go on to look at exclusion clauses based on the type of loss. So saying moving away from culpability, but rather looking at, say, the distinction between direct and indirect losses. And finally, we'll look at an approach where instead of focusing on, the type of loss or the nature of the loss, you just focus on putting a cap on the liability, a total amount.
I suppose one thing I should say before we start, and maybe the health warning for this, is that we speak generally. So there may be, and there definitely are, specific rules relating to particular areas which prevent certain exclusions. So, for example, specific rules relating to consumers or to sale of goods.
Great. So let's start with the first example, right? So a total exclusion. I can see why this is intuitively attractive. I could draft a contract where I say, look, I'm taking on some obligations here, but I simply do not want to be liable. I want to exclude all my liability, regardless of how it arises, even if I willfully default under the contract. What do you think, Katherine?
I mean, I think it sounds pretty nice, actually. But we do see some controls on this, as you would expect. So you can't limit your liability for certain dishonest offences. I mean, that seems sensible.
Yeah.
So you can't limit your liability for fraud or fraudulent misrepresentation. You can't limit your liability for negligence, where that negligence causes personal injury or death. Again, that seems sensible. You can't limit your liability for negligence causing other types of loss, where the Unfair Consumer Terms Act, which is a particular piece of legislation in the UK, where its reasonable test is not met. But we should also note that actually those standards don't apply to international contracts, and those Unfair Contract Terms Act doesn't apply to M&A or shareholders agreements.
Yeah, okay. So I think here we have a key distinction from Danish law, right? So you talked a little bit about dishonesty offences, fraud. I think that's the same position under Danish law. You then talked on about negligence, and I think the general position there you were saying is you could generally exclude liability for negligence, but there's certain instances where you can't,
Exactly.
where the Unfair Contract Terms Act applies. But the scope might be limited. And I think there under Danish law, there's issues with excluding liability for gross negligence. So there's a distinction from Danish law. Another area I think which is quite important here is willful misconduct, right? So you never actually raised a statutory or common law control relating to willful misconduct. So under English law, I can simply exclude my liability for willful misconduct as long as these other controls are met.
Yes,
Yeah.
you can.
And I think we'd just say the one caveat there is where you've totally excluded your liability in such a way that it's rendered the contract ineffective, right? It kind of looks more like a statement of intention if there's nothing standing behind it.
And I guess in that respect, there's no possibility of enforcement against a breaching party, so the courts will effectively strike out that exclusion clause.
Yeah. And I think this is an important point around these controls, right? So we've talked a little bit about, this first example is where you want to go really broad. I'm simply just excluding all liability. But we've identified here certain instances where liability cannot be excluded. And so this is why you see a common English law drafting technique where you would state the exclusion clause, but then you will set out specifically the areas where you cannot exclude your liability and accept liability there. Yeah. So we move on to the second area, Katherine. So what about this idea of excluding liability only where there's a certain culpability. So say only where there's gross negligence or willful default or fraud.
And that is commonly done. And I guess that's a market standard position that we see, for example, in agents in financing transactions. But in that case, there are also controls.
Exactly, like we just talked about with negligence, right?
So then we move on to the third type. That's exclusion based on the type of loss. And what these do is they limit the liability of a breaching party. And they typically say they won't be liable for indirect or consequential loss. The general position under the English law of contract is that damages are only recoverable where losses are foreseeable. Otherwise, they would be seen as too remote. So I hear you saying, well, how on earth can we limit liability? Or why do we want to limit liability for indirect or consequential losses? Aren't they too remote? And the courts in England, in a famous case, we won't get too much into the case law, but famous case of Haddy against Baxendale, said, well, actually, two limbs, these direct losses and also indirect and consequential losses, they're both recoverable. So what are they? Well, direct losses, as you can imagine, are losses arising naturally from the breach of the contract itself in the ordinary course of things. But then indirect losses, they're losses arising from the special circumstances of the case. And you might be thinking, well, that sounds a bit vague. Why would I ever agree to pay those losses or have liability in respect to those? And that's why parties often try to carve out liability for this second limb of indirect or consequential losses. But I think the thing we do need to think about here and recognise is that both are recoverable. Just if something seems remote doesn't necessarily mean that the parties won't be liable for it or the breaching party won't be liable for it.
Okay, so we've got the general common law position where both direct and indirect loss is recoverable because these are two foreseeable categories of liability. Indirect loss being something which was within the reasonable contemplation of the parties at the time of contracting. But then the parties try to carve out indirect. Is it so easy then for a court to come in and say, once a type of loss has been incurred, was this direct or indirect? Take, for example, loss of profit, right? Yep. So generally parties might think when they're excluding indirect loss, they're also excluding loss of profit.
Because they might say, well, actually, that arises from those special circumstances of the case. It wasn't foreseeable to us at the time of entering the contract that you would lose that profit.
Yeah. And this is perhaps a common misconception because it might end up being a majority of the time, loss of profit is actually considered direct loss. It is naturally flowing from the breach, right? And I think just to get a bit more concrete, there's a couple of good examples here. We have the Hilton Hotel case, which involved the supply of defective minibars. And there the court said, well, look, we've got direct loss, which is the cost of going out and buying replacement minibars, somehow containing the loss. And finally, also the loss of profits from the minibars. Then the question was, what about the loss of profits generally from the hotel? Because, there might not have been minibars for a certain period of time. And that was the question, well, was that direct loss or indirect loss? In this case, that was indirect, right? Another example we had here was of a party which bought a floating hull. And the normal purpose of the floating hull was to carry coal. Now, instead, in this instance, the buyer used the hull to carry certain equipment, and the carrying of the equipment was more profitable than the carrying of coal. So could they claim for the losses relating to the carrying of the equipment from that contract? And the courts here said, well, in this instance, this is not indirect loss, the loss relating to the contract relating to the carrying of the equipment, because it wasn't within the contemplation of the parties at the time of contracting.
And I guess that's a really good example of looking at those special circumstances of the case. For example, I assume in that case that if that hull had been used half the time to carry coal and half the time to carry equipment, the courts probably would have said that was a consequential loss.
Yeah, it was foreseeable at the time. Yeah. It's true. Okay, so consequential, direct, indirect loss, and consequential loss being another term, I guess, indirect loss. Quite a fine distinction. And it's, I think, one key takeaway is to remember that loss of profit isn't necessarily indirect. We move on to the final one, just including a cap. You'll often see with these liability exclusions relating to direct and indirect, you can end up with quite torturous drafting, right? It's a long clause where people are stating different types of loss, which is excluded. And one solution around this is just to say, look, I'll accept any type of loss, but here's just a cap amount.
And I think also another nuance to that is you do see that lengthy drafting perhaps trying to exclude certain types of loss, but including a cap.
So how do we wrap up here? Well, we say that, as a starting point for exclusion clauses, you should ask yourself when you're drafting them, are you looking here to limit liability, exclude liability, and what liability should you actually accept being the liability you can't carve out?
And I guess you also need to think about, well, what are those types of losses? So loss of profit, for example, is typically direct, but it could also be indirect. So you've got to be very careful about how you draft that and what buckets of loss you capture.
The final key point with drafting exclusion clauses is that, very sort of clear drafting is required if you want to exclude liability. The courts will generally interpret them against the party looking to rely on it.
And as a theme that we see throughout this podcast series, wording is important for the English courts. They will interpret the contract strictly against the party seeking to rely on it. So clear drafting is always important.
Perfect. Well, thanks very much for joining us, and we hope you listen in to our next podcast.
You have been listening to a Kumaran podcast. The podcast reflects our legal specialist view of the current state of the law. Please be advised that the state of the law is always subject to change as new case law emerges.